sent a correspondence. Possibility of being on.
What says the state?
State basically, Judge, I think in this letter, she just reaffirms what she'd said before, which was not a reason to strike for cause, Judge. The defense has peremptory strikes they could use on her if they want to, but and nothing changes in the letter here as far as legally whether she should be struck for cause. I'd just ask Your Honor to deny the defense's reopening of a request to strike this juror for cause.
All right, the defendant's motion is denied. There's nothing new in this letter other than what was revealed in the jury selection process, and she says that as well in her letter, that we know. Well, we did know, and it was taken into account in the arguments before the court and the court's rulings. So I deny the defendant's request. And that is regarding juror... I know, just a minute. Juror 50 on the qualified juror panel list, and she is the 12th juror down in the pool of 45. I'm sorry, Mr. Kilgore. Now, what did you want to say next, sir?
Also received a operative health care. September 25. The court has received warning this juror.
Says the state.
The state doesn't have any objection to bringing her back in to question her briefly.
I don't see any reason for that. This happened after we had the jury selection process. Nothing whatsoever to indicate that she was scheduled for this before. It appears to be elective. I disagree with you all. And this is not an adequate letter. It says this is surgery that was it appears to be elective surgery. There's nothing in here indicating an emergency, an emergent situation that happened between jury selection process and now. We can bring her in here. I I would say something that happens after the fact, something that does not appear to be emergent, is very questionable for any action of the court other than y'all are aware of it and can take it into account in your jury selection process. However, since both of you have said bring her in, we can do that. So this is going to be juror 29. I have it here. Okay. $27. Okay. All right. If someone can go get Mr. Juror 99. 27 on the new list. Good morning, how are you?
Good.
We have a note from you, and I think that the parties want to ask you some questions.
Good morning, ma'am. Just one quick question. Is this something that was, I guess, scheduled after the jury service stuff had happened? After you'd come in here?
It was scheduled after, but I was in the process of being worked up during that time, to the point that I didn't make a point with the surgeon until after the 2 weeks of questioning because I couldn't get in. So that was it.
Thank you.
The surgeon did not want him wait that long. That was her choice. I did let her know that I had the jury duty coming. However, because of compression, she did not want to wait and the growth that it's growing. All I can do is tell you what she wanted me to have it done. I've been in the process of having this worked up before, and I didn't say anything because I didn't know which way it was gonna go, because I told her I did have the jury. I don't know, I mean, it's compressing and it does cause pressure. I mean, I'm not in pain or anything. But when I went to her, like I said, I could not schedule to see the surgeon until after the 2 weeks that we had of questioning, and the dates kept getting changed, you know. So that Tuesday, when our panel was finished, I went ahead and called, and she got me in on that Friday, and she felt like that it needed to be done before 2 months down the road or 6 weeks down the road. Well, the other thing is this, I've got several nodules. There's so many they cannot be biopsied. So it will go to pathology after I have my surgery. At this point, I don't know what to tell you. I mean, she felt like it needed to be done. I know it's at the last minute. It's something that started prior to all of this, even prior to my jury summons. I know it's at the last minute. It's not something that was intentional. Think about jury duty versus a surgery, and I am a nurse, okay? Having your throat cut, I mean, 6 one, half does the other.
Y'all want to confer with each other about that juror? That's not a nice way of saying confer with one another about that juror.
Judge, we're up.
I'm gonna leave her in the panel. I'll leave it up to the parties. Pardon? What is the status of our person who's not gotten here yet?
All the jurors are here.
Good. We're ready for jury selection. Is there anything else for the state
No, Your Honor.
and for the defense?
Just some direct alternates. Without a stop, in other words, if we get.
Yep. 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 Yeah. Is that what you had planned? That's what's normally done.
I think so,
Is-
Judge.
Any problem with that?
No, Judge. And if we go, let's say we both agree on the first one, I think we just start with the next one and go that way with strike, whoever's there.
Mhm. And Brian's just gonna come, and we're gonna do it silent. And he'll go back and forth, shuttle diplomacy, if you will. And then I'll call you up to the bench to see if there are any bats and problems. If so, I'll excuse everyone and we'll have hearings. If not, they'll be seated and I'll send them to their jury room. Does anyone foresee a problem with that?
No, Judge.
That's pretty typical. Okay, let's bring them in. Gentlemen, y'all might come up here, ladies. Or just, I'll just take two of y'all. No offense, Mr. Evans. I made you hop up. and down. Thank you, Deputy. Good morning, ladies and gentlemen who've been called as prospective jurors. It's good to see all of you again. Thank you for that. I want to introduce myself again to you. I'm Mary Staley Clark. I'm a judge in the Superior Court of Cobb County, and you all have been called as prospective jurors in the case of the State of Georgia versus Justin Ross Harris, General Bill of Indictment 143124. We've all gotten to know one another over the past week ago, over 2 weeks. But just to refresh everyone's memory, I'd like to ask the parties to introduce themselves again. Mr. Boring for the state.
Thank you. Chuck Boring with the Cobb County District Attorney's Office. Jesse Evans, also with the Cobb County District Attorney's Office.
Good morning, Susan Treadaway with the Cobb County District Attorney.
Mr. Kilgore.
Good morning, I'm Maddox Gilmore, and
Morning, Carlos Rodriguez for Mr. Harris.
And I believe the district attorney from Cobb County is here. Is that true?
That's correct, Judge.
Mr. Reynolds, it's good to see you. And we're ready for jury selection. And let me explain to you, ladies and gentlemen, the process that we will use. The process we use is referred to as a silent selection process. And what's going to happen is Mr. Phillips of our clerk's office is going to come forward, and he will go from table to table as the lawyers make the selection of the jury. They'll be thinking and analyzing and making decisions, but we will do this in a silent manner, just so they can concentrate fully on what they're doing as they make the jury selection process. So I would ask you to be quiet and not speak to one another. I would ask you to be as relaxed as you can. Yeah, I've said that to y'all before, and I got the looks. I know how y'all feel about that. But seriously, be as relaxed as you can, and let them go through the process of the jury selection without you all chatting with one another or visiting with one another, because it is work on their part that needs study and thought and concentration, and we don't want to break that study or thought or concentration. Mr. Phillips, if you'll go forward, please. Taking notes, please. I dropped it. Ladies and gentlemen, we have a jury. There are too many machines up here. Lord knows what the future will have. We'll each have a drone. I'll have a little drone by my head, and it'll talk for me. And if I have to wait in line, it'll wait in line for me. And they'll start colliding. Our drones will have fights. Who knows what the future holds? I hope that's not true. Ladies and gentlemen, we have a jury selected from your number. I want to thank you all for your patience while we made the jury selection process. As I call your names, I'd like you to hold your hand up. And we're going to have to do by initials, and number, and the numbers are all different. So keep in mind where you're seated, because that's how we're going to go. As a member of the jury, juror number 1, J.G., has held her hand up. Thank you so much. Juror number 2, C.P., you're in the jury. Thank you, sir. Juror number 4, C.P., you're in the jury. Juror number 5, S.M., you're in the jury. You can put your hands down as we go. Thank you all. Now, I'm not going to make you do that for forever. Okay. Juror number 7, M.H., you're in the jury. Juror number 16, and that's going to be P.E., you're in the jury. Thank you, ma'am. Juror number 17, P.O., you're in the jury. Juror number 19, J.J., you're in the jury. Juror 24, J.R., yes, sir. Juror 25, G.G., hold your hand up. Juror 27, J.J., hold your hand up. Juror 28, K.M., hold your hand up, thank you. Juror 30, K.S., hold your hand up, thank you. Juror 33, James, J.G., hold your hand up, yes, sir. Juror 36, L.G., hold your hand up. And Juror 39, B.B., hold your hand up. Okay. All of you whose names were called, I'd like you to stand and go with the bailiffs and Mr. Perdue into the jury room. And before anybody leaves, let's get a head count, make sure I've got everybody accounted for. What is it? If I called your name, you held your hand up, go with the bailiffs to the jury room. We want them in the jury room. I'm so sorry. So, if I called your name and your hand was held up, you'll come this way. As they say in the South, we're in the South, go that way. You don't have to go in the jury box. No, they don't need to go through there. Y'all come around there. Yeah. Go through that door.
That's the fastest way.
Oh, it is fast way? Okay, go.
That's the fastest way.
I stand corrected. It won't be the first time. Is it really?
Yep. Just do a roll call back there.
Oh,
Just
it
do a roll
sure
call.
is.
Check off. You need a pen?
Yeah.
There you go.
I'm sorry, y'all. I didn't know that was there.
Roll call.
Get a roll call. Bill, can you come up here? Do they have checks for them? Go till I'm sure everybody is in the right place. Understand that you've received your compensation for the day, and so as soon as I'm sure that the people that belong back there are there, I'm going to be excusing you. Let me say to you that I very much appreciate having worked with you over the past 2 weeks and today. You showed up on time. You were courteous and pleasant to us under circumstances that might cause some not to be that way. You took the time out from the other things that you needed to do, had to do, and wanted to do to come to this courtroom and deal honestly and truthfully with circumstances that called you to have to go and talk about things that you might have considered to be private or topics that you did not want to. And it's part of our civic duty. We have a responsibility in an orderly society to do these things. It doesn't mean that it doesn't have its personal component or its difficulty. It would be wrong for me not to express to you that we recognize that. Everyone in this courtroom recognized as we were asking questions and going into topics that as human beings that there would be and could be and was an emotional component. I think the lawyers did a very good job of they're very professional, but also courteous and respectful to you. You all gave that back to us, courtesy and respect. Okay, that's our Wizard of Oz moment. I don't know what to say. Okay. Well, I'm not going to shorten what I've got to say. What I've got to say comes from my brain and from my heart. Thank you. Thank you very much for making a long and drawn-out process from the part that you gave us as pleasant and professional and cordial as possible. We've been welcomed into your community, and you're part of this community as citizens. We appreciate that very, very much. With that, you're at liberty to leave the courthouse. Yes, sir?
Can we read the newspaper now?
Yeah. You are as free as a bird, as they say. Thank you all so much. Yes. Thank you. Thank you for that. I appreciate that very much. All right, let's build our record. Were the jurors called consistent with the notes of the state?
Yes, Your Honor.
Were the jurors called consistent with the notes of the defense?
Yes, ma'am.
Are there any motions regarding the seating of this jury?
No, Your Honor.
And with the defense as well? They stand seated and they are back in their jury room. Don't think there's anything to do with them right now. I'd like to address our attention to motion 28 that was reserved the last time we were together, which would have been Thursday. It's a state, I guess it's, you had said you wanted to offer evidence, I believe. Was that correct?
Yes, Judge. We can have a 5-minute break for witnesses upstairs. I'll bring them right down.
Yeah, we can take 5 minutes for everybody. We're in recess.
Judge.
Okay, 5 minutes is, let's say a quarter till we'll get back.
Thank you.
That's not 5 minutes.
It's 10.
It's 9.
It's whatever you say it is, Your Honor.
That's a true answer, but it's not a good one. All right, we're in recess. I can't get my computer to work. It was working? I think it said I'm not on the internet. Jim, we can visit about this. Back in our little space. Jim, do you have an office? What do you have? this courtroom is flipped from the other. Is that about the size of it? Okay. And totally different than what we're used to. All righty. All right, we're back in session and the defendant's in the courtroom. A bit of housekeeping. I wanted to remind the ladies and gentlemen of the press that during breaks, all sound equipment is to be turned off so that if counsel needs to have a conference with the defendant, that will be privileged as the law requires and not subject to being overheard by anybody. So it's extremely important that that occur because otherwise there are going to be delays. I'll have to give them some place to confer with their client where it can't be overheard. And the easiest and most convenient place is to let counsel use counsel table when they want to. And if I have to stop everything, it'll, spend our time in a way we don't want to spend our time. We want to get the case tried. So if I could ask the ladies and gentlemen of the press to be cautious of that and be mindful of that. I know you've been instructed. I know you're being mindful of that. I just want to remind you of that and call it to your attention. And I know you'll be accommodating, and I appreciate it. Are we ready for Defendant's Motion 28?
State's ready.
We've had what is I consider to be in the nature of an opening statement. I don't think we need to retread that unless for some reason one or the other of you feel that it's worth an opening statement. If you've prepared something, that's fine. If you just want to move forward, that's fine. I'm happy to hear what you have to say about that.
Judge, I don't need to say anything more other than this involves an issue regarding a detective who showed a single photo to an individual to confirm some information that they already knew from an otherwise independent investigation, and that's the subject of the motion.
Do you have anything to add, Mr. Kilgore? No, ma'am. Okay. All right. Let's proceed.
Call Detective Ralph Escamillo.
I do.
Be seated, please.
All right, sir, you are Detective Ralph Escamillo, is that correct?
I am.
You have a court reporter who's seated in front of you. If you could spell your first and last name for her.
Ralph, R-A-L-P-H, Escamillo, E-S-C-A-M-I-L-L-O.
Where are you currently employed?
I'm employed by the Cobb County Police Department.
In what capacity currently?
Currently, I'm assigned as a crimes against person, robbery, homicide detective.
Have you always held that position, or have you held other functions within Cobb County Police Department?
I've held several other functions, such as crimes against children, SUV detective, organized crime intelligence, vice crimes unit detective, and uniform patrol officer.
Back in September of 2014, which unit were you assigned to?
I had just transferred over to the robbery homicide unit.
And transferred from what organization or what group?
I was previously assigned to the Marietta, Cobb, Smyrna Organized Crime and Intelligence Surveillance Unit.
I want to talk a little bit about your work with OCU, as we commonly refer to it. Is that correct?
That's correct.
Okay, your work with ICU, did that involve any prostitution operations?
Yes, we were involved with any kind of vice crimes, gambling, prostitution, escorting, white-collar crimes.
Have you participated in an undercover capacity in the past involving stings involving prostitution?
Yes, I have.
And have some of those operations involved the use of cell phones, either by text or phone calls?
Yes, they have.
Could you please explain for the record the typical course of conduct in making contact with a prostitute so that you could continue an investigation into those types of matters?
Yes, initially you would have a number identifying somebody working in the capacity of an escort or prostitute. At that time, you would make a phone call, an initial phone call to them to make contact with them to find out about their services and availability. They would generally tell you whether they were available or not and the services that they offered. If it was agreed upon that you would utilize that service, they would tell you to call them back when you were in the general area, and they would give you a general area to go to. You would then drive or walk or whatever to that general area, make a secondary phone call to advise them that you were in the general area. They do these several calls to avoid law enforcement detection. At that time, you would advise them that you were in the area. They would give you a more specific location, such as the name of the hotel and where to park or where to enter the hotel at.
How many of these investigations do you think you've conducted in your course of your career?
Several dozen, I would say probably 60 to 70.
And have they usually, at least when it involves a cell phone, involved these multiple phone calls that you've referenced in order to set up the transaction?
Almost always.
And I want to talk specifically about some of the areas where one might find escort services. Can they be found online in some capacity?
Yes, there's several bulletin boards or listings that list services such as these for people that are looking for those kind of services.
Backpage, would that be one of them?
Yes, Backpage, Erotic Review, Craigslist, Escort.com, stuff like that.
Okay. I want to direct your attention now to this specific investigation. About how long had it been since you transferred from OCU to the Robbery Homicide Division when you were called upon to participate in this case?
I believe I was transferred over in March of 2014, and I began assisting in this investigation September 2014.
In specific, in this particular case, what were you tasked with doing as a support role to the lead detective in this case involving prostitution and that aspect of the investigation?
I was approached by my supervision, and they handed me a series of telephone numbers that were derived from the defendant's call history log from a cellular telephone that was seized from him. My task was to locate the individuals assigned to these phone numbers and find out who they belonged to, and to follow up with them to see if I could confirm that they had been contacted by this individual, the defendant.
There's one particular individual that's the subject of this motion. I'll just use the last name, Mrs. Doerr, correct?
Correct.
That's D-O-E-R-R, correct?
That is correct.
And there's in particular a phone number that was found in the defendant's cell phone associated with her. Is that correct?
Correct.
Looking at that phone number, which begins with 678 and ends with a 318, were you able to do any investigation into that phone number to see if it was associated in any way with illegal escort service?
Yes, I utilized that phone number and entered it into the search engine on my computer, work computer. At that time, it generated the search, and it showed that that number was associated with websites such as Backpage.com, the adult section, as well as the Erotic Review, which is an adult website for escorting and prostituting.
Based on that, on or about September the 8th of 2014, pursuant to your mandate given to you from supervision, did you attempt to make contact with Ms. Doerr using that number?
I did. I ended up planning an operation with my immediate supervisor, Sergeant Wheeler, as well as a support agent, Agent Panchame. At that time, we were going to use the pretense of having me call that number as a supposed customer and to arrange a meeting time with Ms. Doerr at her location.
Now, this particular phone number, you had talked about the process of setting up meets. When you looked at the defendant's, I'm going to refer to it as the work phone, how many times did you see that he had contacted her back in May, specifically May 31st of 2014?
I found that he had contacted her 3 separate times, outgoing calls from his phone to Ms. Doerr's phone number.
May 31st of 2014.
That is correct.
Is that consistent with what you had just described in terms of your setting up meets with prostitutes during your investigations?
That's correct.
Based on that, did you make any attempt to contact her directly?
I made a phone call to her directly to that number listed, and I advised her that I was interested in making some time with her or making a date with her, which is the street slang for meeting with her. At that time, she told me that she was available and to call me when I was in the area of Franklin Road in Marietta, Georgia. I advised her that I would. I then responded to that area with Sergeant Wheeler as well as Agent Panchame, and prior to calling her back, we met at an undisclosed location, which is standard procedure for us to form a plan of action, and then I made a secondary phone call to her. During that secondary phone call, I advised her that I was in the area and she advised me to come to a hotel, the Econo Lodge, which was down on Franklin Road, about a quarter of a mile. I was instructed to pull into the parking lot and to park, and to call her a third time once I was parked in the parking lot.
We have to make a record here, but it goes without saying you had not at this point identified yourself as a law enforcement officer. Is that correct?
Correct, specifically because in my experience in the past, if you identify yourself as a law enforcement officer to somebody who's advertising in this capacity, they will not, they'll hang up on you, will not call you back, and then they do not answer calls after that.
You contacted her on the pretense that you were a John or somebody interested in her services. Is that accurate?
Correct.
Once you met with your command and support staff, did you have any discussions at any point about what the plan was going to be in terms of actually making contact with this individual?
Yes, prior to leaving the office and upon our initial meeting when we got on the Franklin Road, it was decided that we were going to make contact with her if it extended out to that far where I was able to meet with her. There was never any intention to take her into custody or to arrest her. This was merely to confirm the phone number, whether she was in possession of that phone, still the originator of that phone, and whether she can confirm that the defendant had called her, in fact called her or met with her.
You used the word confirm. Had you already identified the defendant as having had contact with her from an independent source, that being the phone records?
Absolutely. The forensics on the telephone had already showed that the defendant's phone or hand unit had called Ms. Doer's phone previously.
On that final contact you had by phone with Ms. Doer on September 8th of 2014, please describe what, if anything, was generated from there. Did you agree to meet?
We did. I made the third phone call from the parking lot. I had advised her that, or prior to that, when she gave me the hotel, I advised the support agents, and they responded ahead of me so they could set up at the hotel. I then arrived at the hotel, made the third phone call, and she advised me that she was in the lower level of the hotel towards the back, and she gave me the specific room number. At that time, I notified the agents that what room it was. I repeated it several times as I was wearing a transmitter that was a covert transmitter. At that time, I received a text message from Agent Panchame advising me that he got me okay on the transmitter and they were okay with the room number. At that time, I exited the vehicle, walked into the lower level of the hotel, and I did a sweep, which is walking past the identified room that she had given me, just to make sure that there wasn't anybody laying in wait, and then returned back to the room, knocked on the door, and at that time she answered the door and invited me into the room. Once inside the room, I did a secondary protective sweep where you visually check the bathroom area or the closet area as you're walking in just by looking at it. You walk deep into the room to the very back to make sure nobody is hiding behind the beds or curtains or what have you, and then you place yourself into the center of the room where the other agents know where you're specific to be in case they had to respond in case of emergency. At that time, with Ms. Doer, I made small talk conversation with her, and at that time I gave her undisclosed amount of MCS official funds in the form of U.S. currency, and at the time she accepted the currency, and at that time I identified myself as a Cobb officer.
And how did you identify yourself as a police officer specifically?
Generally, I sanitized myself prior to that by removing any type of firearms or any kind of ID, police ID and stuff, in case I'm patted down. In this circumstance, I was wearing a badge on my belt loop. This badge identifies that I'm a Cobb County police officer or detective, and at that time I showed the badge to her and I identified myself as a Cobb County police detective, and that I wanted to speak to her in reference to something that was unrelated to this.
Okay. And did you have further conversations about this investigation once you identified yourself as a police officer?
Yes,
Was she cooperative with you?
she was.
Out of abundance of caution, did you Mirandize her?
I did.
And did she agree to waive her Miranda rights and speak with you in the presence of the other agents that came in to support you?
Yes.
And how long, once you gave the takedown signal, was it before the other agents were present at the hotel room with you?
I would say less than 30 seconds.
Having Mirandized her and obtained a waiver, can you describe your interaction with her and the confirmation of the evidence that you had already obtained for the court?
Yes. After I identified myself as a police officer, she seemed like she was taken aback. She was kind of startled. I told her to calm down, that everything was going to be okay. At that time, I advised her that I wanted to speak to her about some phone calls that had been made to her in the past. And at that time, she stated that she was okay. She wanted to cooperate. I advised her of her Miranda rights. She waived her rights, and at that time, I asked her if she had seen an individual that I was going to show her in a picture. I had a picture of the defendant that was sanitized, meaning there was no identifying information on it. I showed her that picture, and she said that that the person in the picture looked familiar, and that she remembers him as being dumpy, fat, and she stated that he had a large head. At that time, I asked her if she was 100% sure what the percentage was, and she said she was about 90% sure. However, she was unsure about the clothing. I asked her to elaborate on as to why she could be 90% sure, and she stated that she uses 2 hotels on Franklin Road, one being the Econo Lodge and the other being the Ramada across the street, based on their location to a quick trip, and she can see the parking lots from those rooms. She states that she usually dates African-American Johns or customers, and that during that month, she remembers dating a Caucasian male that was fat, dumpy, and it appeared to be the individual that was in the picture. But again, she was unsure about the clothing that the defendant or the individual that showed up was wearing.
Prior to showing the photograph to her, did you give her any sort of admonishment about what you were about to do in terms of your discussion with her?
Yes. I usually tell people when I'm talking to them that it's just as important to, identify somebody who's involved in something, and just as important to let someone go who wasn't involved in anything. Just as a caution, she stated that she understood, and then that's when she went into the details.
I want to talk about some of the factors concerning and surrounding this confirmation that you did with Ms. Doer. Did she talk at all about the length of time she interacted with the defendant back in May of 2014?
Yes, she stated that she remembered that the date was a 30-minute date for $125 in U.S. currency, and she did remember that the date with this individual was very boring, very plain. She used the term vanilla. She stated that there was nothing special about it, nothing that would stand out as far as the service. I asked her specifically what the service was, and she used the street term of half and half, and I asked her to confirm half and half, meaning fellatio as well as sexual intercourse, and she did confirm that the half and half was that.
In terms of her degree of attention, did she say specifically where this happened at the hotel that you referenced?
Yes, she remembered it happening inside the hotel room on the bed. She stated that they both had disrobed and they were nude, and that they had covered fellatio. She performed covered fellatio on him as well as protected sexual intercourse with her.
Okay. And she did say that she completed the transaction. In other words, she had sexual contact with the defendant that she identified, correct?
Yes, and that was why she said it was so boring.
Now, the level of certainty, I think you've already covered that a little bit. I want to make sure we get the number for our record, though. What was the percentage of certainty she said regarding the photograph?
She stated it was 90%, and then she stated that the clothing she was just unsure of.
And the length of time between the interaction and your contact with her, you made contact with her directly in September 8th of 2014, correct?
Correct.
And then the phone records revealed that his contact, him being the defendant, Mr. Justin Ross Harris, that was May 31st of 2014, correct?
Correct, and she confirmed that for me while I was on site.
And I want to ask you about that. She offered to do something to be doubly sure of the confirmation of the photograph. What was that?
She stated that she has access to her e-bill or electronic bill with her phone carrier, and she's able to log on and research her records. I advised her that that wasn't necessary, that it was up to her whether she wanted to do that, but I wasn't forcing her to do that. She said that she wanted to help and she wanted to confirm whether he had called her or not, even though I told her that the phone records that we had from the forensics showed that. She logged on to her e-bill and she researched the dates, the date that I gave her, and she pulled up the 3 phone calls and she showed me on her electronic tablet, these are the 3 times that he called me, and this is the phone number that he called me from.
So consistent with the extraction report of defendant's work phone where you found these 3 calls, did you also see and observe and corroborate those phone calls from this independent source, that being Ms. Doer and her e-bill records she pulled up for you?
Yes, I did.
Now, going into this operation to identify Ms. Doer, and can confirm the information that you already had regarding the phone extraction. Had you had any discussions about whether she would be arrested or not, depending how things went?
Yes, we had already discussed that based on the investigation that we were doing, we wanted, again, to confirm whether she was in possession of that phone number still and whether she remembered the phone calls that were made. And we had planned that we were not going to take her into custody based on the investigation that we were doing.
Consistent with that discussion, after your interaction with Ms. Doer, was she arrested for this, I guess you would call attempted prostitution involving your interaction with her? Or did you stick with the plan that you had discussed with your hierarchy or your command staff that she was going to be let go?
Yes, as a matter of fact, she had asked me a couple times during the conversation in the room in the presence of Sergeant Wheeler and Agent Panchme whether she was under arrest, and I advised her that she wasn't. And she also asked me whether she was going to be charged with a crime or charged with prostitution. I told her she was not.
Right, thank you.
Detective, you talked about confirmation, or asked specifically about confirmation. Telephone number from Mr. Harris's cell phone, right?
Correct.
But you had no information whatsoever that Mr. Harris had actually met with anyone associated with that telephone number, correct?
Correct.
So when you're talking about, you're testifying about confirmation, confirming whatever phone that she has possession of.
No, that's not accurate. I was confirming that he had called, or his phone had called her number, and those phone calls, the three of them, had some time on them as the duration. So we were confirming that he did call her and what the conversation was about and whether she remembered it.
Phone log that you had of his.
Correct.
You had absolutely that she had ever
Correct. Correct. Possibility, yes.
This was a planned operation in September of 2014, right?
Correct.
Wasn't any sort of urgency. Quickly, was there?
I was tasked with the assignment and I carried out the task. No. Correct.
That's not what happened here.
No.
In fact, Mr. Harris was actually in custody.
That is correct. Correct. I do not have it with me. When I printed it out originally, it was the book and photo, and then it was cropped, just the picture minus his information, his statistical information. After the operation, that document was shredded.
But, you're supposed to retain whatever.
I'm not aware of that. Yes.
If you weren't in a hurry,
I did not prepare a six-pack or a six essential lineup because I was not investigating. He had already been identified. I wasn't charging her with a crime. I wasn't charging him with a crime. I was merely confirming the information from the call logs and the phone calls that were made. I needed to corroborate whether she remembered a person calling from that number and if she remembered what that person looked like.
spoke to her, and your testimony was that you had her ID, a photograph.
Correct.
And you were,
I was not having her ID that photograph. I was asking her whether he looked familiar or not based on the phone calls and the date.
this was a bookend photograph?
Correct.
Was it color?
Yes.
Have any other sort of markings on it?
No, it was, again, the booking photo that was cropped, and it was merely the face up to about mid-chest, neck area. It was not jail clothing, such as what they're given, scrubs or whatever you call them. It was civilian clothing.
What kind of civilian clothing?
The best of my recollection, I want to say it was a polo shirt. The polo shirt? I don't recall. I want to say there was color to it.
Photograph color?
Yes, it was.
And you would agree that this, well, I guess we're calling it a non-identification now because you're talking. So this non-identification, it was actually a couple of months after you believe that they had had contact, right?
I believe it was a little bit more than that, but yes.
May the 31st to the first or second week of September.
Correct.
Did you ask her how many customers that she'd had in that 3 plus?
I did ask her about customers. I don't believe I asked her specific numbers, but that is when she stated that she dated African-American customers and that he stuck out because he was Caucasian. I don't recall whether she did or not.
Did you ask her?
I don't believe I did.
Right. You knew who she was before you spoke to her, correct?
No, I only knew her phone number, and I had a picture of her from her ads from the back page
All right.
advertisement.
Were you aware that she had marijuana arrests before and after you spoke to her?
No,
Where she was on probation at the time you spoke to her?
I believe she did tell me that she was on probation, I believe.
Did you ask her if she was high on marijuana at the time of this encounter in May of 2014?
No, I did not. She seemed to be very clear and lucid.
Spoke to her in September. Asked her if back when she was working. At the time.
No, I did not. No, I do not.
Spoke to her that time you busted her. High on marijuana at that time?
I never took her into custody. She was never charged with a crime. When I was speaking to her on that date, the 8th, she was clear and lucid. She answered questions and she even asked questions. I didn't see anything that would lead me to believe that she was under the influence of any narcotic based on my training and experience.
Did you search her person or her room?
No, I did not. I did not ask to search her personal possessions. I did a mere cursory search when I walked in just to make sure there was no weapons out in the open or any kind of thing that would harm me.
Did you or anybody else that came into the room find any marijuana on her person or in her room?
That first, it's been asked and answered, and second of all, it's not really relevant to the issue of the motion that the defense has filed.
Likelihood that she may. Secondly, there was marijuana in the room. And this witness credibility. So I think it's extremely relevant.
Your motion goes to the conduct of the police officer, not the conduct of the witness. Certainly, you can cross-examine, well, I'm not going to say certainly. It might be appropriate when we're in the case in chief, but for the purposes of motion, goes to the impermissibly suggestive single photo identification procedure that created, according to your motion, a substantial likelihood of misidentification. So I don't find it relevant.
I think the question I asked was if he or anybody else had. That is the question I asked him.
I am. But I'm not saying that that's the ruling in the case in chief, is when we get into it. I'm just saying for the purposes of your motion, the way you've articulated your motion.
You would agree that if someone
I would say that marijuana affects people differently. It is a possibility.
let's go at this from another way now. Did you give
No. No.
given her an ultimatum that she was either going to cooperate with you?
No.
They have called her and
Correct. Yes, that's what I asked her, or told her.
suggested to her, I'm going to show you a picture of somebody that you met with in May 2010.
Yes, I did say that I was going to show her a picture of that.
So, showed her the picture. She certainly wasn't the one that came up. Oh, hey, this is somebody I met.
The phrasing of that question, what he put in her mind that would call for speculation about what was in her mind.
No, I'm not asking what was in her mind. I'm asking if he put it there.
That's a matter of argument.
Okay.
I'm sorry, I just sustained the objection. Perhaps.
possibly a client that she met with in May 2004.
Correct. Correct.
And at the time you showed it to her, had just served her in the commission of a crime.
Correct. 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 The covert transmitter that we utilize is also serves as a recorder. Depending on the amount of time that you use it and battery life and what have you, it's supposed to record and also transmit to the surrounding officers that are in support. On this operation, when we went back to download the information from the recorder transmitter, it did not transfer over. It showed that there was no information on there. It malfunctioned, which has happened in the past.
Were there any benefits
Absolutely not. As a matter of fact, I told her that she wasn't being charged with the crime. She was free to leave at any time if she wanted to, and she didn't have to talk to us. When she agreed to speak to us, I even asked her if she wanted to speak outside her room if it was more comfortable to her, and she stated no, she would rather speak inside. It was more comfortable to be inside so nobody knew her business.
crime you're talking about was solicitation?
Excuse me?
You told her she wasn't going to be charged with a crime.
Yes,
You're talking about solicitation.
any crime.
Any crime?
Correct. I wasn't there to take her into custody. I was there to confirm information from the phone records.
How to determine whether or not make an ID for you, so I want to know, was there any other crime that you could have arrested her for?
There was no other crime that I could have arrested her for. She was there when I conducted the operation to make contact with her. The only other charge could have been solicitation. That was it. But I also had discussed previously that we had already agreed on that we weren't going to arrest her.
Right. I remember
Correct. I was there to confirm the phone number that had called her, confirm her phone number as well, and whether she was in possession of that phone number when the 3 phone calls were made. I do. Correct. Yes, it does say that.
testimony, you were not asking her to make an identification.
Well, again, in the report it says, or whether he looked familiar.
testimony still that you not asking her to make an identification?
Correct. It is my testimony that I was not there for her to make an identification. It was to confirm and corroborate the information that I already had at hand.
Would you agree then with that line in your report is wrong? Identify him.
I would say it was not incorrect. I'm asking her two things. I'm also asking her whether he looked familiar. I'm asking her if she recognizes him. I'm asking her whether he looks familiar, whether she remembers him.
Correct, that we need to remove.
Object to that being argumentative. I don't think he said that it was incorrect.
I sustain the objection.
Cobb County Police Department does in fact have a written SOP, very specific procedure.
Yes, I agree on that. I am.
Object on two fronts. First, I want to know whether this is the current SOP or the prior SOP. It's been changed by law, some statutory changes. The other portion is relevance because it's not an identification procedures by the SOP.
I sustain the objection.
That sustaining to any question about SOP? That you did this. Part of the procedure is photo array. Photograph.
I agree. If you're doing a photographic lineup, yes, that would be accurate. No, because I wasn't doing a photographic lineup. I was doing a confirmation as to the numbers that I was given that had made phone calls from Mr. Harris's phone to Ms. Doer's phone and confirming that those calls, if she remembered those calls.
I understand. Also had her identify a photograph, right?
I asked her if he looked familiar. The defendant was already identified. We already knew who he was. It's not like we were looking for him. I was confirming the information from the telephones and then asked her if he looked familiar.
Isn't it true? Never been identified by her. Photograph. He had never been identified by her.
Correct.
So when you showed her that photo and asked if she
As far as me showing her the photograph, yes. I don't know whether she has seen him prior to that or if anybody else had ever shown her a photograph or other than the contact that they allegedly had.
Well, are you aware that any other officer had preceded you?
No, I'm not aware of that. But I'm speaking for myself. That's the only time I have showed her that. If you're showing a photo lineup, yes, that is correct.
Here, you didn't bother to get a lineup, you just had one bookend photo.
Correct, because I was confirming the phone numbers. I wasn't conducting a photo lineup.
Okay. Well, let me ask you this. If you showing her a photograph of somebody doesn't confirm a phone number, does it?
The answer to the first part of the question, yes, I could have asked her that, but I didn't ask her that because she, on her own accord, showed me her e-bill and the phone, incoming phone calls. The answer to the second part of your question is, yes, I could have asked her just that.
I may have asked two questions at one time.
You did.
I apologize. Showing her a what her answer is doesn't confirm.
It could, because she can associate it with the phone number if she remembered it. I wouldn't know that without asking her that question.
I think that's argumentative, so I reject the argumentative.
Answer? Want to rephrase?
I think the answer is obvious. I won't rephrase.
Probably sustains the objection.
Isn't it true? Document the photograph.
Relevance is not a photo lineup that was being presented, apples and oranges.
Sustain the objection.
Was this a one-on-one show up?
I don't understand the question. No, I do not consider that to be a one-on-one show up, and that was not the purpose to be a show up. Again, I was there to confirm and to corroborate the numbers between the two.
Was it a lineup?
No, it was not.
Because you didn't use a six-pack photographic line.
Again, I wasn't there to conduct a show up or a lineup. I was there to confirm the information from the phone numbers.
Because you weren't there to have her make an identification, the fact that you had her make an identification. We can't really challenge it because that's not what you were there for.
Well, the answer to the first part of the question, no, I wasn't there to show a photographic lineup or do identification. We already knew who the defendant was. He'd already been ID'd to us. The second part of your question, no, I don't think that's fair to say. I wasn't there to do a lineup or a show up.
Why'd you take a picture? Have her identify anybody, why'd you take a picture in there?
It was just something that I had to ask her whether it was, he looked familiar. Maybe she remembered the phone number associated to that person.
I think I understand. Your position is that,
I don't know whether she would or not.
and you certainly would agree that standard operating procedure was and still is, that you're to preserve photo or photos that you have shown.
If you were conducting a show up or a lineup, a six-pack or a sickle essential, yes, but that was not my purpose there. I wasn't conducting either one of those.
So Gore, while you look at your notes, I'm going to talk to Mr. Sharon about jury management. Cross-examine.
Have a few other
Sorry, redirect.
In addition to Ms. Doer, were you tasked with looking at other searches for other prostitutes in this case?
Yes,
And did you find some of that information on his phone as well, consistent with what you found through the Doer investigation?
yes, the numbers that were given to me to include Ms. Doer's. I also identified a couple of other ads that were related to the adult section of escorting or prostitution websites.
Okay, and did she indicate to you, that being Ms. Doer, how many other white customers she had in the month of May, or did she indicate this was the only one?
She stated that in the month of May, she remembered she only had one, and that he was overweight, fat, dumpy, and that he was at the Ramada.
Despite the fact that this was not a photographic lineup, did you nonetheless give a verbal admonishment to her prior to showing the photograph?
I did.
And what was that admonishment?
I told her that it was just as important to be able to say that you don't recognize someone as it was important to be able to say that you did recognize somebody.
When you began talking with Ms. Doer, you had already confirmed through your investigation that she was involved in prostitution activity. Had you already confirmed that she was involved in prostitution activity prior to speaking with her?
Yes, by the mere nature of the websites that I found associated with the phone number.
In addition to that, your telephone conversations with her, did that assist?
Correct. The undercover operation that we conducted where we exchanged information related to services.
I'll show you a statement. For purposes of this hearing, will be one of. Is that a fair and accurate copy of the photograph that you showed Ms. Doer, that being the booking photograph of the defendant?
Yes.
Tender States 1.
Admitted.
Looking at facts on Mr. Harris after he was arrested and the photograph states 1 that's been admitted, is it consistent with the description, albeit it was a layperson's description, consistent with the description that she gave you? Objection.
Yes, the physicalities I found to be consistent.
Heavyset white male?
Yes.
Okay.
That further? This Friday?
Testimony now is that this is the same photograph 42-year-old. I think her that you wanted to show person. Started that interview with. I began the interview by asking her for general information for the report, and then yes, that is the picture that I showed her. Picture that you showed. After you told her that you wanted to see. I said, that client met with her sometime in May of 2000. I believe I said that after I showed her the picture, or while during showing the picture. Because I asked her, it said, if you looked familiar, I then showed Ms. Dewar a booking picture of Mr. Justin Ross Harris that was absent of any identifying information. She looked at the picture and stated the male looked familiar and remembered the male being fat and dumpy, but she could not provide any name or any identifying information. And then that's when I said, I advised Ms. Dewar that this male possibly contacted her in the month of May. So it would have been after, according to the way you asked me the question. I just read that from my report.
Well, let's go through this. Go along with me in the report and tell me if I'm wrong. Starting in the second paragraph. Midway. Set a meet time, and she provided me with directions to a hotel. Location again.
Correct.
Making contact with Ms. Dewar and identifying myself as a police officer detective. I advised Ms. Dewar to speak to her about a possible client that may have called her and or met with her sometime in May 2014.
Correct.
Great. Told her that's what you wanted to meet with her about, a client that she may have met with in 2014 before you ever showed her this photograph.
Correct.
Okay. Said that she doesn't see a lot of white people,
Correct.
correct? White,
Correct.
okay.
Correct.
Hair color,
No.
she didn't say
No.
facial hair.
No. No.
That's one very prominent mole on his chin. Do you see that?
I do?
Right. She didn't say anything about that mole, did she?
No.
Okay. All messed up. It's all bent up. Left side. Can you see that from here?
I can see his ear from here.
Clear across the room, you can see it. She didn't say anything about that, did she?
No. Yes, ma'am.
You have another witness?
No.
I believe we're ready for argument.
I'll reserve closing.
Their motion.
It is. It's state to burden.
True.
Judge, let me
Okay.
start out with were you ready for me, Judge? I'm
I
sorry.
am. I'm just, it's a complicated burden issue, but that's fine. State wants to take the burden, I'll let them. Okay.
Let me start with the obvious, and
That is the very circular sort of testimony that you just heard. It's clear from the testimony and from the report.
absolutely. Whatsoever. Detective, of the witness, photograph.
Telling him that, hey,
After telling her, hey, maybe somebody that
And so, we're challenging the procedure.
Challenging this identification issue. Witness's position, which I assume is the state's position, is, well,
There's no ID here.
no identification procedure. They don't follow SOP and do a six-pack. It's not a lineup. It's not a photo lineup. Challenged is an ID procedure because witness to individual to do a traditional show-up. So the identification procedure can't be challenged.
That way because, well, it's not a show-up. And so what they created by saying, well, it's, we were there just to confirm a phone number. So because of that, there's no identification procedure to challenge a procedure.
So circular, Judge, and it doesn't make any sense at all. Clearly, this was an identification procedure.
And they're using the fact that it wasn't done properly as some sort of an excuse.
Well, we didn't do it right. I mean, we didn't do a six-pack.
We had plenty of time to. I mean, he was in custody. So because we didn't do all that, you know, it really wasn't an ID procedure. Well, I know the court understands what I'm saying. I know the court heard the testimony, and I would ask the court to very succinctly just see right through that. The law is pretty clear here, and the court was reading.
Impermissibly.
Witness was even shown the photograph. Already told. Already primed. She was already told. Right after he made contact. Speak to her. I advised Ms. Dorr that I wanted to speak to her about a possible client that may have called her or met with her sometime in May 2014.
Here's the information that they are giving her.
Time frame, May 2014. Extremely suggestive. We've also got the fact, Judge, that
Call it incentive, basically. Whatever the
well, because
anybody they show her photo of.
they only showed her one photo.
Primed her, made it very suggestive. Hey, we're talking about somebody that may have met with you for prostitution services. May, we got you under our thumb because we got you for solicitation. Identify, or if they look familiar.
Extremely, extremely, extremely suggestive. 20-1.
I'll go line up. That's exactly what.
Cases, the cases are very clear that that type of one-on-one show-up.
That particular. Because of the circumstances of
This particular,
this particular procedure.
Thank you.
Provide some documents to the court. That I'll be very brief. Folder, stacks of documents. Judge, to frame this issue very simply, I could pose this hypothetical to the court. Say Detective Escamillo showed up to the hotel room and Miss Doer said, "Lawyer, not talking to you." Say that no photo had been shown to her at all. This court has already ruled that we are able to present this evidence within the context of 404B as being intrinsic evidence, evidence of motive, and 404B evidence, even if she were not asked to view a photograph at all. We have his phone records showing that he definitively contacted her. We have proof that she's involved in prostitution, plus we have additional evidence that he had been seeking out escorts through other phone records that Detective Escamillo was also asked to look at. That's the proof positive that we're really not talking about an identification procedure here, but a confirmation, which is different. Because say she had looked at the photograph and said, "I just don't remember, I see too many people." The state would still be presenting this evidence based on the circumstantial nature of the evidence and the contact between the defendant and Ms. Doer, consistent with the court's prior rulings on these types of issues. But I think that frames the issue such that you can see that this is not really an identification procedure. This is rather confirming the information that the police officers already had. I will point out that, by the way, Ms. Doer is under subpoena, and I would expect that we're going to call her to the stand during the trial of this case, absent something changing. Even if for some stretch of the imagination you were to say, well, I believe this is some sort of identification procedure rather than confirmation of the evidence that police officers already have, I would ask the court to consider some authority that I've provided to the court. Regarding single photograph procedures, Georgia appellate court decisions have clearly distinguished between cases of identification versus confirmation or corroboration, where single photographs are merely used to confirm a suspect's identity that is already known to the police. And I'll cite Jackson versus the state, 279 Georgia 449. That's a 2005 case that actually cites to a Cobb County case, Hansberry, Hansberry versus the state, 260 Georgia Appeals 480, which was a 2003 decision. I've also provided the court several cases that I think might be instructive should you find that this was not confirmation, this was some sort of different type procedure. Miller versus the state is a case that was tried in Cobb County that did actually involve a show-up. It was tried before Judge Stoddard. I was the prosecutor on the case. Detective Escamillo was actually the lead detective on the case. And the Court of Appeals affirmed the conviction where victims in that case were brought to a show-up where the defendant was, I believe, handcuffed at the time, arguably much more suggestive than what was done in this particular case. And nonetheless, Court of Appeals found that there was no improper procedure for identification in that case. State v. Hatney is perhaps the next and most instructive case for the court. That's going to be 279 Georgia 88. That's a March 2005 case. In that case, it was arising out of Fulton County. The trial court actually granted Mr. Hatney's motion to suppress an out-of-court identification pursuant to single photograph. Thereafter, the court ruled, well, maybe I'll let you revisit it, Fulton County, and see if you can prove identification at trial, because I believe that this person was known to them. The Supreme Court of Georgia actually reversed the trial court in Hackney and says, no, you have to allow for that single photograph if your finding is that there's an independent basis for the witness to come in and testify at court, because the standard is the same. Judge, there are a series of cases that I could cite for the court, and rather than do that to save time, I provided the court with Marchman versus the state. There's a companion case, Arnold versus the state. I know Mr. Kilgore knows this case because it was a murder case that was tried in front of Judge Boterford, and he was the defense attorney that represented Mr. Arnold. Mr. Marchman, the co-defendant to Mr. Kilgore's client, claimed that the use of single photographs to confirm, not to identify, but to confirm, was error. And just this past June 2016, the court affirmed the convictions on both of these defendants. I provided, in conjunction with this, a brief that was submitted at the trial level for the Joshua Marchman conviction. It has an abundance of authority regarding the distinction between identification procedures and confirmation procedures. The site to the Marchman-Arnold decision is 787 Southeast 2nd, 734. It's got a Georgia Lexus site. It's too new to have a full Lexus site. 2016 Georgia Lexus 421. Judge, similar vein, if you look at Lindsay versus the state, which is a copy of a case that was provided to the court, that's 1987 decision, 182 Georgia Appeals 10. There's a lengthy discussion about identification procedures, if you were to call it an identification procedure, and basically they say there's no per se exclusion of in-court identification because of the suggestive pretrial identification, and that there should not be inflexible rules of exclusion that may frustrate rather than promote justice. There's a couple other cases that I provided to the court as well. Because I've given them to you, I don't need to put the cites, I don't believe, on the record. You have that authority to look at. I do want to point this out, Judge. I printed off a copy of each of the defendants' cases cited in their motion. If I'm reading these cases correctly, and I believe I am, they have not cited a single case in their motion that stands for the proposition that you're required to suppress this out-of-court identification or any in-court identification. Unless I'm mistaken, I read all of these cases to be convictions that were affirmed by the U.S. Supreme Court, by Georgia courts, by other courts as well. So they failed to bring you a single piece of authority, at least within their motion, that would mandate that you find anything other than what the state has argued to the court, that this is confirmation procedure, not really an identification procedure. And again, I point to the fact issue here that had Ms. Doer refused to even cooperate with the police, we would still be able to go forward with proof of identification based on his records and based on her being involvement in this activity alone. Now we have additional corroboration in that we have this e-bill that was provided to Detective Escamilla as well. So, Judge, based on that and based on the authority we've provided to the court, we ask that you find that there's no impermissible identification procedure. Just out of abundance of caution, if you were to find that this is some sort of identification procedure, then we would ask you to look at the totality of the circumstances as you're required to do. Lindsay says that you must do that in order to determine whether there is a factual basis such that we can present in court or out-of-court testimony. Those factors would include opportunity to view the defendant. I'll point out that there was at least a 30-minute interaction. This involved sexual acts. It was the most intimate of interactions that you could have between Ms. Doer and the defendant. Next factor, describe the degree of attention. You've heard that was a 30-minute encounter during sexual acts. Again, perhaps the most, I don't know that you can have acts that are more intimate than that. Describe the accuracy of her description of the defendant. Well, she used some terms that may not be terribly flattering, but fat and dumpy, big head, only white man she's seen at the motel. His records confirm that he had contact with her. He is a white male. He is heavyset. I think you can see that from the photograph and from your own attention to him. Describe the level of certainty of the identification. Pretty high here, 90%. She didn't say, I just can't remember. I'm 90% sure. Not sure of the clothing, but he was the only white guy, and if that's the white guy in my records, and by the way, they are, she pulled up the e-bill to confirm that, then that's pretty high level of certainty. Length of time between the crime and the identification, I'd suggest to the court that it's relatively minimal. I'm sure it wasn't the exact next day, but the interaction was an intimate one on May 31st of 2014. And just a hair over 3 months later, police are having an interaction with Ms. Doer to confirm what they've already found to be the defendant's identity from his own phone that was seized from him. So based on these arguments, Judge, and the authority that's been provided to the court, I would ask that the court find that there's no basis to grant defendant's motion number 28 and allowed us to proceed forward with presentation of both the pretrial and in-trial identification, if she can. And quite frankly, we might ask the question, do you see him in the courtroom? And I suggest that she might be able to identify him. She may very well not be able to, but that's not really the dispositive issue here, because we have an independent basis for identifying from his own phone himself and what was revealed from her e-bill.
Well, as to defendant's motion 28, the state's first argument about a week and a half ago was that it wasn't a proper vehicle to bring this matter to the court's attention. I think there is some merit to that argument. And I had the hearing in an abundance of caution. I'm going to deny defendant's motion 28. I find this to be a confirmation rather than a identification. All the independent evidence led the investigation to the defendant. Assuming it were a show-up or for identification, she did meet the requirements of being with him a substantial period of time. There's a short period of time between the act upon which the identification would be made. They spent time together. Her identification of him is consistent with his appearance, and the picture shown is consistent with his appearance. So for those reasons, I deny defendant's motion 28. I note the defendant's exception to the court's ruling. Before we break for lunch, is there anything else from the state?
No, Your Honor.
Before we break for lunch, is there anything else from the defense?
No, ma'am.
All right, let's have a break. We said 1 o'clock. That's not enough time. Let's come back at 1:30. Let's come back at 1:15. Let's make it an hour. We're in recess.